Welcome once again to the Finance Forum. I'm Abdu-Raof Hanslo. In this edition, we look at a very pertinent topic to you, the consumer, and myself when looking at my life and where it will end eventually. Today, our topic is estate planning and what happens once we leave this beautiful earth. My guest in studio this evening is Mr. Etienne Wilsnach from Alchemy Financial Services, a regular guest now on the Finance Forum. Good day to you, Etienne. How are you?
I'm good, Abdu-Raof. Thank you.
Always good to have you in studio.
Awesome being back.
You know, we get excited about very little in today's world, but the excitement to me is always knowing that there's a specialist in his field sitting across from me in studio.
Thank you. Kind of you.
Etienne, I think, you know, the topic of today being estate planning, it's something that is probably one of the most important parts of financial services or financial planning. However, it's also one of those subjects that becomes elusive to most of our community and our viewers. Can you firstly, before we go into the basics of estate planning, give us a synopsis of exactly what estate planning is and where it fits into financial planning?
Okay. So financial planning is broad, but in my personal view, the foundation of financial planning is set by what we call estate planning. In other words, I've acquired assets in my lifetime. I've got property, I've got bank accounts, I've got motor vehicles. The question is, if I pass on, if I died, what happens to these assets? How are they distributed amongst my kids, my wife, my family? And the document that we know as a last will and testament is exactly that. It is the document that stipulates the distribution of my assets in my passing. The most critical document that you should have in your financial planning portfolio. It is the foundation of everything else.
Now, you know, when I mentioned earlier, I said this is probably one of the most elusive topics when speaking about financial planning, because I don't think anyone wants to be morbid and speak specifically about death and what comes after death. You mentioned clearly that it's all to do with what you leave behind, and that's all dialogued in your will as your last wishes, basically, on this earth. Now, Etienne, for the benefit of our viewers, who specifically needs it? Is it anyone, or is it just specifically the wealthy?
So in theory, it says if you own property, okay, and you pass on, you need to tell people where your property should go. It's the understanding of the term property that causes the confusion. A lot of people view property as my house. Anything that you own that is registered, including your bank account, your motor vehicle, that's all deemed as property. Okay, so if you're not sure if you qualify or if you should be the one, then speak to your financial advisor, but do not avoid the conversation. I think the limitations you spoke about earlier is the fact that we have cultural issues around it, and then in our community there's this massive perception that only white folk have wills. We need to get beyond that you see, as generations change and people have become wealthier and people have acquired more property, the need for the will has become critical. You have to have the conversation.
Now, obviously, when looking at your estate planning, it's not something that you would sit down and do by yourself. So, is this something that you do when sitting with your financial advisor, or are there other institutions who would offer this service to the community or as a client?
Yes, they are. So your first step would be to chat to your financial. If you have a financial advisor and you have a relationship with him, it would be easier for him to do that because he has insight into your life and what you have in your portfolio. But there are institutions like our life assurers. Old Mutual has dedicated segments of the company that deals with estate planning. So there's an Old Mutual Trust. Often your banks would also have a department within their bank that deals with trust. So if you're uncertain, you can approach either your bank or your financial institution that you're familiar with.
And your financial advisor.
Ideally. As I said, it's simpler for him because he knows your life. He knows how many kids you have, if you are married, if you've been married before. So for him to draft that, and my bit of advice is, you know what, if your financial advisor today had not had the conversation with you. Yeah.
You mentioned now that basically, so it's various different organizations and institutions in South Africa that would basically offer this service, and it's basically made very accessible to the public.
Yes.
But yet, research shows that 95% of our community, of the public of South Africa, do not have wills, and ultimately, if something happens to them tomorrow and they have an asset in their name, there's going to be an issue. Why is it that 95% of our community doesn't prescribe to this fact of having a will?
I wish you could tell me. Actually, I'm intrigued by that question because you rightfully, only 5% of people that should have either a valid will or a will in place. And you can have the debate around cost. There are many institutions that actually do it for you at no cost. So the initial drafting of your will is for free. So that takes that off the tick box because there is no cost to it. I have to say people just haven't paid attention to that. They haven't dedicated the time to sit with an individual and say, let's draft the will, let's get it signed off, and let's get it in place. What often happens, they have the initial conversation, but the signing off of the document in its legal form never takes place.
Now, I think the only approach you can basically go in with this is to scare the living daylights out of a community to say, this is exactly what would happen if you don't have a will.
Absolutely.
So if one paints a scenario and says, okay, fine, I have 2 houses, I have 4 cars, I have a bank account and a life insurance policy, and I have investments to the value of R1 million lying around. If I die tomorrow and I don't have a will, what happens, Etienne?
Beautiful question. So there's a legal term called interstate succession, which means I died without a will.
Yeah.
Okay, so let's assume you're a married community of property and you pass on. So from that example, it's wonderful because there seems to be a lot of money. But let's assume then you have not left any beneficiaries on them for some reason, and you haven't really allocated funds directly to your wife, which means it needs to go through the legal process of being distributed after your death.
Yeah.
If you haven't had a will, the master of the Supreme Court will then decide how these assets would be distributed, and there's a formula that refers to bloodline and who gets first. The problem is that period is indefinite. It could take 5, it could take 10 years for that to be resolved in the Supreme Court, and that is the threat. So it could not mean that, no, my husband did not leave me money. He left money, he just didn't say when I should get it or who should get it.
Yeah.
And until that decision is made, the family is still destitute. They still don't have an income. They could even lose their property, because if mom's at home and she's a housewife not generating an income, you know what, how is she going to service the bond repayment? Because the master of the Supreme Court's going to decide when she's going to actually get her late husband's funds. That's one example. The other one's a classic. A lot of people do not know that if they have been married before, so let's assume they were married and they had a will, and they get remarried and they had not changed their will within 90 days of their divorce, the law will assume that you wanted your assets to go to your ex-wife.
Grief.
Okay, which means, your present wife will come and fetch you from your grave.
Yeah.
Okay, that is a reality. People do not know these laws. They're not familiar with that, and often due to neglect, they would not initiate the second or the new will with the second marriage, and that could be a problem.
Now, besides the fact of creating a will, there's also, we all have retirement annuities, we all have pension funds, we all have insurance policies, life insurance policies. And in that regard, in that scenario, many a times we find that there's a little piece of paper at the back of your application form for the retirement annuity, where you appoint beneficiaries to the proceeds if anything happens to you. Does the will supersede that document, or does that stay intact irrespective of what the will says?
No, actually the nomination of a beneficiary supersedes your will.
Okay.
So if you have a life policy, and you have left the proceeds of that life policy to your wife, okay, it doesn't matter what is stated, and that must be paid to the wife. Will that ever be taken into consideration in the calculation of estate duty and executive fees? But it doesn't form part of the will. So in other words, it will not go, simple term, it will not go through the will before it's paid out. Okay. But the calculation will be added. For the winding up of the estate, but the proceeds will be paid directly. So if there are funds that you do not want to complicate, and you've got proceeds that you do not want to form part of your estate, nominate a beneficiary.
Okay. Now, Etienne, obviously, in today's day and age, things change quite drastically. I mean, you lose a spouse, become divorced, you lose kids.
Yes.
In that regard, your will would obviously be made out at a specific time, and life changes as you go on. How often should a will be renewed or reviewed or upgraded?
So there's not a specific timeline, but I mean the advice really is that if any set of circumstances in your life had changed, the addition of a new child, divorce, the passing of a member of the family or the partner, even if there's a specific request, let's assume you bought a second property, but you wanted that property to go to your eldest son. Yeah. You would want to then look at it. So it's not something. This is the nice part of estate planning. It's not something you have to do regularly. You know, if you have a proper will in place and it meets your requirements as your family situation is at the moment, you don't need to change it. Okay. What people forget, however, is that wills are date bound. So the one with the most recent date will supersede anything prior to that. So there's always the question. You said, Etienne, but I used to have one at ABSA 20 years ago, and I had one in 1999, and I'm drafting a new one. Do I need to cancel the others? No, you don't. So if you pass on, they will basically look at the one with the most recent date that has been properly signed and completed, and that one would supersede any wish prior to that date. So it doesn't matter if you had 200 wills before that. The one dated most recent would be the one that's considered.
Yeah. So in your opinion, basically, as changes happen through your life, that's the time you should actually update your will.
Exactly.
As well. Now, Etienne, I mean, obviously, when looking at a will in its totality, there's various appointments that you have to make, just thinking of this in my space, sitting across from you, these are important decisions. Appointment of an executor, the appointment of trustees, if necessary.
Yes.
And I think before we go further, can you basically just give us a synopsis of exactly what the role of the executor is, and in the event that a trustee needs to be put in place, what's the role of the trustee?
Okay, so the executor is basically the person that takes care of the administration process of winding up the will. Okay, one of the I would call it a mistake I've seen is that people become emotional about the nomination of this individual. So somebody would say, my brother is an accountant and I want him to be my executor. I personally have witnessed that as being a mistake. So if you're going to use a big institution that has an estate arm to it, rather nominate them as the executor. That's what they do. So people say, but I'm going to pay them. The cost of an executor is regulated by law. So nobody can charge you. They can discount you, but they can never charge you more than the 3.99% that's inclusive of VAT. The problem that I have seen personally is people nominate somebody on emotion. They pass on, and 6 months after their passing, that individual has been either unable to or not willing to go to the effort to wind up the estate as the executor. And 6 months have been lost because they never get to it. And inevitably they sign over trusteeship back to an institution anyway. So unless that person that you nominate is involved in winding up of estate, or that's what they qualified, they're an attorney, etc., I would say consider that. But if your family member is a teacher or head of the post office, please reconsider that as an option. You can nominate them as a co-trustee. In other words, they will have signing off power after they've assessed it, but they wouldn't need to be doing all the work up front.
Yeah. Okay. Now, obviously, this is a lot of people we see today make decisions emotionally.
Yeah.
And ultimately what you're saying is, don't use your emotions to decide on this important appointments when drawing up your will.
Absolutely. So before, I'll get back to the question on trust, but one of the areas where we see emotion often is the nomination of guardians, for example. Okay, which is critical. If I'm husband and wife, 2 little kids, and I say, if we pass on, who's going to be given the responsibility of raising our kids? Okay, now a lot of people neglect that, and they always say, where there's a will, there's a relative. So we just imagine again a scenario where you've got 2 kids aged 3 and 4 years old, and mom and dad passes on tragically in a motor car accident, and these kids are worth 4 million rand. Yeah. Everybody wants to be the guardian.
I'm sure.
Okay, we have scenarios where single mom, dad's absent in the child's life, mom passes on, employee benefits are paid out to the child, and now dad wants to step in because he's the legal guardian. And those are the measures that you need to protect your child by using an estate document, by using your will. Okay, so nominate guardians, and that's where the emotion comes in. So some people, I want my sister to be my guardian of my kid, but my sister's 19 years old and she's first year university. Yeah. That's where you shouldn't use emotion. You need to apply some logic in the nomination of that guardian, and then have the conversation with whoever you have nominated.
I think a lot of thought must go into basically drawing up the will. And you so rightly said earlier that instead of you doing this yourself, get the correct guidance from an institution, financial advisor, or any financial service provider that offers the service ultimately. Now, Etienne, earlier on you mentioned something that I hung on very quickly, and that was, you mentioned trusts.
Yes.
Now, when looking at estate planning, what's the difference between a trust and a will?
Okay. So a trust is a legal entity that we often use to register in property or assets. Okay, so there's 2 types of trust in South African context. The one is what we call a living trust, and then the other one's called a testamentary trust. So for the sake of this conversation, I'm going to just talk to you about the testamentary trust. So people often say, Etienne, but if I died and I look at all of my insurance policies and my employee benefits, etc., it's worth 2 million rand. My child's only 3 years old. How do I manage these funds until my child is 18, 21, or 25 without abuse taking place and without people ensuring that child within a year would have no money left? So a lot of people don't understand that if you leave a minor funds and you just put it in a bank account, the guardian would have access to that.
And if there's no guardian appointed?
Then whoever the state appoints as a guardian would have access to it. Okay, so let's say it was a single mom and there was no dad involved, and granny was nominated as the guardian. Those funds would go into a bank account and granny could have access to it. So that's where trust is so critical.
That scares the living daylights out of me.
I hope so.
Because I have small kids as well, and from a personal perspective, one always thinks of the future of them if you're no longer there. So in that regard, when establishing a trust for death, as you mentioned, a testamentary trust, is this something that specifically needs to be mentioned in your will? Does it form part of your will?
Absolutely, and people generally ask what's the cost of it, but because it's a testamentary trust, initially there's no cost to it. It's only if it is used or implemented later that there would be a percentage cost to administering it. But so to simplify the debate, if I passed on and my 4-year-old daughter and mom and I both passed, and whatever was left to her, we had nominated that it goes into a trust for her, where it would be managed by the institution. We've nominated 3 trustees, and they will ensure that her schooling is paid, her maintenance to her guardians would be paid, so we can ensure quality of life. And then whatever is left after tertiary, and she's now at the age of 25, would then be made available to her in terms of what's left, the residue. But the management of that income would be taken care of by the trust company itself. Okay, so now that there's control, it's a short of ruling from the grave. It is the only way I can ensure the long-term well-being of my kids through the use of a will.
No, I know we're running a bit out of time, Etienne, but there's one pertinent issue that you also mentioned, and I mean, ultimately, death is a life-changing event. End of life, ultimately, yes. Not a life-changing event. There is no life further than that. It's a life-changing event for those who supersede you, who precede
your surviving members. Yes,
the surviving members who precedes you. So, in that regard, also, I mean, during your life, there are life-changing events, and one of those life-changing events, and we don't wish this upon anyone, is divorce. It's a fact, and there's a high rate of divorce in South Africa at the moment. Is it important to change your will, and what are the legal stipulations around changing the will after divorce?
Okay, so firstly, as I mentioned earlier on in our conversation, it is critical that you do, especially if you've had one before. Because if you've had a will in your marriage before divorce and you did not change that, the state would deem that was your wish. They then would assume that that's how you wanted it. In other words, your ex-partner, if you had left everything to your ex-husband or wife and you pass on, it will still go to them. Yeah. So to disengage that, and to nullify that, you need to draft a new will. Okay. The only thing in South African law is that you cannot, if there's a surviving biological parent, you cannot supersede that through the nomination of a guardian. So if I was divorced and I nominated you as a guardian to my daughter, I cannot do that unless I have my ex-wife's permission. So in other words, if I pass, my ex-wife would automatically take ownership or guardianship of the biological child. Okay. That is purely that. But in terms of the distribution of your assets, I can then protect my assets from the ex-partner by ensuring that in a will I stipulate who should get anything if I pass.
Etienne, from your side, from a professional financial planning perspective, what advice do you have for our viewers regarding estate planning and the drawing up of wills?
Do not waste one more minute. That's why contact your financial planner. If you don't have one, give me a call. I can allocate somebody that will see to your needs. We've got a few institutions that's available to you, but do not waste one more minute. Both husband and wife. Doesn't matter what your set of circumstances. If you want to avoid anarchy, if you want to avoid, now I always say to people, your husband has just passed on. You're dealing with the loss of your loved one. Dealing with the financial issues shouldn't be a problem. That should be taken care of. The reality, however, is you take care of that in your lifetime. Do not wait for the event to happen. We see it even with a senior profile like US Van der Westhuizen. It wasn't done properly, the steps wasn't followed, and now it's a problem. He had passed on more than a year ago, I think, and his estate has still not been wound up. Okay, do not hesitate. Contact somebody and attend to it immediately.
Etienne, thank you. It's always a pleasure having you in studio, and the amount of information that you impart to our viewers is so important to maintaining our lifestyles. You've been watching the Finance Forum with myself, Abdu-Raof Hanslo, and my very special guest in studio, Mr. Etienne Wilsnach from Alchemy Financial Services. We've been speaking wills and estate planning, and I hope that you've learned something from my very experienced and learned guest. Until next time, stay focused to your finances.